Estate planning is no longer confined to paper files and predictable family structures. The future of multi-generational trust planning is being shaped by technology, evolving tax law, and changing family dynamics. For California families, adapting to these changes is not optional. It is essential. Modern trust planning now demands flexibility. It requires digital awareness, legal precision, and an understanding that families' assets and regulations evolve over time. A trust created decades ago may not be equipped to manage cryptocurrency, blended families, or AI-assisted investments. Forward-looking planning bridges that gap. Technology is transforming how trusts are administered. Digital record keeping has replaced filing cabinets with secure cloud-based systems. Trustees, attorneys, and beneficiaries can now access trust documents, asset inventories, and fiduciary reports securely and efficiently. Transparency has improved, but so has exposure to cyber risk. Emerging technologies such as smart contracts may eventually automate certain trust functions. These digital agreements execute automatically when predefined conditions are met. In theory, a trust could distribute funds, update records, or generate compliance reports without manual intervention. While promising, these tools must be carefully supervised to ensure they align with fiduciary obligations under California law. Blockchain technology is also influencing trust administration. Beyond cryptocurrency, blockchain can record ownership of property interests, business shares, and digital intellectual property in tamper-resistant ledgers. For families managing complex estates, this technology may reduce fraud risk and improve traceability. Digital assets are no longer fringe holdings. Cryptocurrency, online businesses, digital securities, and tokenized property are now part of many estates. Trustees must know how to access digital wallets, document private keys securely, and value volatile assets properly. Without clear documentation, disputes can arise quickly. Artificial intelligence is adding another dimension. AI tools can analyze financial trends, identify liquidity concerns, and model future tax exposure. For large, multi-generational estates that include real estate, private equity, and digital holdings, predictive analytics can provide valuable insight. However, AI does not replace fiduciary responsibility. Trustees remain personally accountable for decisions made on behalf of beneficiaries. AI should support professional judgment, not substitute for it. Proper documentation of AI-assisted analysis is essential to defend fiduciary decisions if disputes arise. As estate administration becomes increasingly digital, data privacy becomes a legal imperative. California leads the nation in privacy regulation through statutes such as the California Consumer Privacy Act and the California Privacy Rights Act. Trustees who fail to protect beneficiary data may face liability and reputational harm. Cybersecurity clauses are becoming standard in modern trust instruments. Multi-factor authentication, encrypted storage, controlled digital access policies, and even cyber insurance are now part of prudent fiduciary governance. Confidentiality remains a cornerstone of fiduciary duty, and digital protection is now inseparable from legal compliance. Tax law continues to shape the future of trust planning. The federal estate tax exemption, currently elevated, is scheduled to sunset in 2026. If reduced, many California estates will face increased federal exposure. Flexible drafting, including trigger clauses that adjust to changing tax thresholds, is becoming standard practice. California property and capital gains regulations also continue to evolve. For families holding substantial real estate, ongoing review is critical. A static trust may not withstand dynamic tax reform. Adaptability is no longer optional in long-term planning. Fiduciary access laws are expanding as well. The California Uniform Fiduciary Access to Digital Assets Act provides trustees authority to manage digital property, Future reforms will likely address AI-managed portfolios, tokenized real estate, and increasingly sophisticated digital holdings. Trust instruments must grant express authority to access and manage these assets. Globalization has further complicated estate planning. Many California families hold assets across multiple jurisdictions. International investments, foreign business interests, and cross-border inheritance laws require coordination to prevent double taxation or conflicting claims. Future trust structures must account for this global dimension. Family dynamics are also changing. Blended families, second marriages, and evolving parental roles demand customized trust drafting. Equal distribution models may not reflect emotional or financial realities. Conditional distributions, separate asset pools, and detailed statements of intent reduce the risk of misunderstanding or litigation. Longer lifespans add another layer of complexity. Many Californians now live well into their 80s and 90s, increasing long-term health care costs. Trust must balance elder care funding with preservation for future generations. Special provisions for medical care, long-term care planning, and healthcare subtrusts are increasingly common. Non-traditional families also require thoughtful drafting. Domestic partnerships, same-sex marriages, chosen families, and non-biological children must be explicitly recognized to avoid exclusion under outdated language. Inclusive drafting ensures that intended beneficiaries are legally protected under California law. Younger generations are also influencing trust strategy through values-based investing. Environmental, social, and governance considerations are becoming part of fiduciary discussions. Modern trust instruments may authorize or require ESG-focused investment strategies while maintaining financial prudence. Education has become central to long-term trust preservation. Beneficiaries will inherit not only wealth, but responsibility. Families increasingly hold governance meetings, provide financial literacy education, and prepare successor trustees to manage digital assets and fiduciary obligations responsibly. Knowledge strengthens continuity. The future of multi-generational trust planning lies in hybrid frameworks. Traditional legal safeguards must integrate with digital infrastructure. Secure client portals, encrypted signatures, compliance tracking systems, and transparent reporting tools are becoming part of modern estate administration. The key is balance. Technology offers efficiency and transparency. Law provides structure and accountability. Human judgment ensures fairness and fiduciary integrity. A resilient trust embraces all three. Best practices for the future include early adoption of secure digital systems, periodic legal reviews every 3 to 5 years, training successor trustees in cybersecurity and digital asset management, and incorporating contingency clauses that anticipate regulatory change. Collaboration remains essential. Attorneys, financial advisors, accountants, and technology professionals must coordinate to ensure comprehensive oversight. Fragmented planning invites vulnerability. At Hackard Law, we help California families design trusts that are secure, adaptable, and legally sound. Our approach integrates evolving technology with disciplined legal drafting and careful fiduciary governance. The future of trust planning is not a departure from tradition. It is an evolution. Families who embrace innovation while maintaining legal precision will preserve not only wealth, but shared purpose and stability across generations. If your family is preparing for the next era of multi-generational trust planning, proactive guidance is essential. To future-proof your estate strategy, contact Hackard Law or visit hackardlaw.com. Your legacy deserves protection that evolves with the world around it. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.